Well, welcome back. We've been talking about the role of judicial power in our Constitution. It's a phrase that appears in the Constitution. The Constitution, the written Constitution, contemplates a very important role for the judiciary, and we've been trying to figure out if there's some way of harmonizing the role of the judiciary with the basic precepts of a written Constitution. We've talked about different aspects of judicial power: the power to interpret the document, to say what it means, to implement it, to make it real in the world with all sorts of in-court rules, moving from the abstract meaning of the constitutional text to a bunch of rules that courts and lawyers and lower courts can understand and implement. We've talked about the importance of deciding the case, a thing called res judicata, reaching a judgment between the parties, of establishing certain precedents that have a certain weight, and of providing judicial remedies for the violation of legal rights. Let me say a little bit about remedies, and then I'm going to come back to the bigger question of the role of precedent. I'll start with remedies and move to precedent. You might think, I was pretty harsh back in my Warren Court discussion about the exclusionary rule. I think it's constitutionally made up. It's not in the written Constitution, and it doesn't really have proper foundations in the unwritten Constitution. One of the reasons I'm so emphatic about this is I need to give you at least one example of where the unwritten constitutionalism goes too far. This is a game with rules. And you can't just call anything the unwritten Constitution. And it seems to me that the exclusionary rule is a good illustration of where actually judges not only went beyond the Constitution, which they are allowed to do. They need to do it to do the job, but went too far. I need to show you why that's so. And I said, well, it's not in the written Constitution, and it's not implicit in the deep logic of the Constitution, which is about protecting innocent people from possibly erroneous conviction. And the exclusionary rule instead protects guilty people as such, qua guilty people. The only reason the defendant wants to exclude this evidence is that it caught him dead to rights. And in the process of excluding, we impose all sorts of harms on victims and their families, in tension with deep ideas of truth-seeking and a public trial that's all about actually sorting the innocent from the guilty. That's the deep implicit structure of the Constitution, I argued. So the exclusionary rule isn't in the written Constitution, and it's not in the implicit Constitution, reading between the lines, because that's about truth-finding and innocence protecting. That's the big idea. And those things support Gideon versus Wainwright in providing lawyers for indigent defendants, but not throwing out reliable evidence of guilt. I talked about how the exclusionary rule isn't really part of our lived Constitution. It doesn't really bubble up from the American people and their practices. You know, ordinary people actually believe in truth and sorting the innocent from the guilty. And unlike, let's say, Gideon, the Warren Court decision called Mapp versus Ohio was not merely following states that had already pretty much established the principle. And when it comes to attorneys, paid counsel for indigent defendants, the lived practice in America was to provide for that even before the Warren Court came along. Not so with the exclusionary rule, which the Warren Court applied against the states. So I didn't think it was in the written Constitution, in the implicit Constitution, in the lived Constitution. And you might say, okay, well, Professor, isn't the exclusionary rule a remedy? When the Fourth Amendment is violated, surely there must be a remedy. For every right, there's a remedy. And I say, yes, for every right, there is a remedy. And the framers believed in that. And they built actually their remedial vision into the text of the Fourth Amendment, which talks about the right of the people to be secure in their against unreasonable searches and seizures. What law? Actually, they say the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Now, what law gives you security in your person, houses, papers, effects? It's basically property law and tort law. If the government touches me, that's a trespass. And if anyone else touches me in an improper way, I can sue and trespass. If people come onto my land, invade my house, That's a tort. That's a trespass. And I sue them. And that's what the framers of the Fourth Amendment envisioned, were tort suits brought by people who had been intruded upon. And indeed, the most famous cases of the Anglo-American world at the time of the Constitution, the O.J. Simpson case of the day, if you will, the Brown versus Board of Education case of the day, involved actually lawsuits brought against government bullies who had improperly searched and seized. The plaintiff in one of the lawsuits was a man named John Wilkes, as in Wilkes-Barre, Pennsylvania, and Wilkes County, North Carolina, and Wilkes County, Georgia. The judge was a man named Camden, as in Camden, Maine, Camden, South Carolina, Camden, New Jersey. The Baltimore Orioles play in Camden Yards. These were famous people, famous cases, but they were civil tort cases brought by innocent people against government had intruded upon them. So the remedy that the Fourth Amendment provides is a remedy for innocent people. If the government messes with you, you sue them in trespass. The exclusionary rule doesn't have the right remedial fit. Let's say, for example, the government beats you up. Well, obviously you need a remedy. The exclusionary rule isn't a remedy because it doesn't find anything. It just beats you up. It strip searches you. Once we understand that you have to have remedies for innocent people, which the framers did, I think we see that the remedy is tort suits. Now imagine a tort suit. The two different people. The government actually searches two identical twins, Adam and Bob. They're identical. Both searches are unreasonable and illegal. In Adam's house, they find nothing. In Bob's house, they find the smoking gun. He committed the murder, the bloody knife. He committed the murder. They introduce it against him, and he goes to prison for 20 years. Now, which is the founder's world. Let's imagine that Adam and Bob both sue because their rights were violated by this unreasonable search. Adam gets, let's say, $1,000 let's say $100,000, $100,000 for the unreasonable search or seizure. Bob sues, and he says, well, I had the same privacy violation. They did the same search to me, and they found the knife, and I went to jail for 20 years, so I deserve not $100,000, but $20,100,000 because I went to jail for 20 years in addition. We would never give Bob $20,100,000 in a proper tort suit. We say, you're in prison for 20 years because you're a guilty so-and-so, because you did it. You know, you suffered no more of a privacy violation than Adam. The government wrong was intruding in your house, not finding the evidence, not finding the knife. That's not the privacy violation. Not introducing the knife is no new Fourth Amendment violation. You suffered the same violation as your twin brother Adam. You get the same remedy, $100,000. You do not get extra compensation because you're a guilty so-and-so. So the Fourth Amendment exclusionary rule does not have the proper remedial fit. Remedies have to fit the scope of the right. The right of the Fourth Amendment is about protecting innocent people from being intruded upon in all sorts of ways. And if you're guilty, you benefit to the same extent, but no more. You don't get more rights because you're guilty. You don't get zero if you're Bob, but you don't get $20,100,000 either. You get the same thing that Adam does, because you suffered the same violation, no more. It was no extra violation of your rights that we actually found the knife and introduced it against you. And in fact, if we hadn't found it then, the legal system can tell us maybe we would have found it some other way. And if we had found it some other way, we should have been able to introduce it against you, because the truth should out in a just world. In a just world, if you did the crime, you should be convicted. We want to separate the innocent from the guilty. We don't want to convict you if you're arguably innocent, but the exclusionary rule isn't about innocence. And that's why it's not a proper remedy. Okay, so now I think you have a little bit of a sense of implementation and remedy, interpretation. Professor, what about this precedent thing? You've mentioned it as a component. And what am I supposed to do when the precedent says one thing and the written Constitution says another? Well, the Warren Court faced that all the time. The written Constitution says equal. Plessy, when it comes to segregation, Plessy says, forget about equal. You know, we wink at that. So are you going to follow Plessy, which says we wink at equal? Or are you going to follow equal? That's what made Brown an interesting case, is precedent was on the other side. The text said one thing, the precedent said something else. Which do you follow, the text or the precedent? What does the Constitution say about precedent? What does precedent say about the Constitution? How can these things be brought into alignment? And my suggestion is the Constitution says a fair amount, not everything, but a fair amount, and I think we can tease out some relevant principles. The Constitution says that it is the supreme law of the land. Not what presidents say, not what Congress does, not what courts say. The Supreme Court is the supreme over other courts. It's not supreme over other branches. It's not supreme over the document. It exists under the document. The Constitution, the supreme law, is above and over the Supreme Court. That's what the Constitution itself says. And if you always followed precedent, even if you were sure that it was wrong, we'd eventually be drifting away from the supreme law of the land. It would be like a game of telephone, you know, the kids' game where you whisper into someone's ear and she whispers into the next person's ear and you go around. And by the time you get to the 12th person, everything's been completely garbled. Well, that's what the world would look like if we always followed precedent without checking every so often to make sure that the precedent hasn't drifted way off course, way away from the core constitutional principles. So I think the core idea of the Constitution says it's supreme, not the judiciary, nor the executive, nor the legislature for that matter. So, Professor, are you saying there's no role for precedent at all? No, I'm not saying that. I think the Constitution itself recognizes a certain role for precedent, a limited role. Let me identify three important precedential components. One, vertical precedent. The Supreme Court, it's not supreme over the Constitution, but it is supreme over lower courts. Lower courts are inferior to the Supreme Court. That's actually the Constitution uses the word inferior courts twice, in Article 1, Section 8 and Article 3. So these courts are inferior to the Supreme Court. So if you're on a lower court, your job is actually not to channel the written Constitution as best you can. It's basically to pay attention to what the Supreme Court has said and done. In effect, to pay attention to what Anthony Kennedy thinks, because he's the fifth justice on the Supreme Court on many issues. And that court is supreme over you. And if there's an open question, if the Supreme Court hasn't decided anything, well, then you have to look to the written Constitution. But otherwise, an inferior court takes its orders from the Supreme Court. It's the lieutenant, it's the captain, it's the major. It's not the general or the field marshal. That's the Supreme Court. So the Constitution itself gives us a hierarchy within the judiciary. Lower courts have to pay attention to the Supreme Court's interpretation. Okay, now you're on the Supreme Court. Now you're Justice Kennedy, for example. What are you supposed to do if you take seriously your constitutional obligations? There's an earlier Supreme Court case that says X. You think the text of the Constitution, fairly read, says Y. Which do you go with? Well, one thing you do is you might want to, at the very least, make sure actually that that other court, take another look at that earlier court decision, because those were justices just like you who were trying to do their job, and you might want to, there might be deep wisdom in what they said on second thought. When you look at it again, you might say, I originally thought the Constitution meant Y, but there's this earlier case, and it was decided by John Marshall, and it says X, and it's John Marshall. And then I think he may have had he had a pretty good idea of what the Constitution meant. So the earlier cases, especially ones by very well-respected justices, may have, let's call it persuasive authority, epistemic weight. They might actually influence what, on second thought, you believe is the best interpretation of the Constitution. And that's a weight that precedent has. Precedent is also the starting point. The Supreme Court does not, like the House of Representatives, die every 2 years and just emerge again with a completely new set of, possibly, of people. It changes very gradually. It's a continuous body, in the same way that the Senate is a continuous body. And a continuous body, by its very structure, this is an argument about the written Constitution implicitly as a whole. Its structure suggests actually a certain continuity. So at the very least, you can say, I'm going to follow precedent unless I'm persuaded otherwise. That's my starting point. I'm not going to try to rethink every single thing afresh on every case. I start with the precedents. They are now, if I'm persuaded that they're wrong, I'm going to give them a second look, because maybe they were right and maybe I was wrong in thinking that they were wrong. So they're my starting point. They have some persuasive weight, especially if it comes from someone like John Marshall or Joseph Story, some particularly respected jurist. They're my starting point. They're my persuasive weight. But if at the end of the day I'm persuaded that the Constitution really says something else, generally the Constitution says it's supreme. Any additional exceptions? 2 more. 1, the judicial power applies to things that have already happened, to transactions that have already occurred in the world. It is specific and retrospective. That's the nature of judicial power. It acts upon cases and controversies that have already arisen, stuff that's already happened in the world. Now, if the people who have acted in the world were acting in reliance on earlier precedents and organizing their conduct in relation to this earlier precedents, that is an equitable factor that the judicial power properly takes into account because it's designed to be retrospective. So reliance interests are important. They are built into the nature of judicial power, which talks about judges having cases in law and equity. It's an equitable consideration that judges may permissibly take into account. If the parties have acted in reliance on a precedent, even if the precedent is wrong, that might influence who should win between the parties because they reasonably relied on the precedent. But going forward, the court might say, you know what? Okay, we think we were wrong before. We can't change things in a way that upsets settled expectations, but we might announce in today's case that we think we were wrong before because when it comes to future cases, maybe actually we're putting people on notice that a different rule might be sensible. There was a wrong committed. The wrong was our own previous court case, and we're supposed to fashion a remedy for that wrong. And the remedy might begin by saying, we goofed, and in the future we need to try to think about how that goof might be corrected. Maybe the legislature can come in as well. So the first step is not to refuse to acknowledge that we were wrong. It's to admit that we were wrong, to say so, to say what the law is, and then to think about how a proper court should function with due attention to reliance interests of the parties and a proper remedy going forward. For example, I happen to think paper money is easily and obviously constitutional and issued by the federal government. Suppose you thought that was wrong. Well, even if it's wrong, we've had 100 years in which people have been relying on these green pieces of paper as legal tender for all debts, public and private. It would be crazy for a court to disregard the reliance interest that had arisen thanks to the earlier case. And judicial power, to repeat, permits attention to reliance interests in the proper resolution of the dispute. Second, equitable principle. The Constitution talks about the rights of the people. They're not always specified. They're unenumerated rights of the people. Suppose a case was wrongly decided at T1. It announced a right, and the right really didn't properly exist at the time. But since then, since T1, the American people have really embraced that misinterpretation. We've come to believe that that is our right. Well, if so, maybe today at time T2, we should affirm that precedent rather than overturn it. Even though it was mistaken when issued, now the American people have embraced it as a new right, and the Ninth Amendment says that there can be additional rights. There can't be less rights than the text permits, but I'm giving you a case where actually the court announced an additional right. Maybe it was a mistake at the time, but now the people have embraced it, and the Ninth Amendment itself says that the people can have new rights. And their understanding of new rights can come about in all sorts of ways because of their lived experiences, because of social movements, because of changes of technology, because they actually, if you thought Miranda was made up, well, but maybe you say, well, the American people have embraced Miranda today. And even if it was wrong at the time, today, actually, it's an unenumerated right of the people. And even this fellow over here, who I'm going to tell you a little bit more about, his name is William Rehnquist. Early on, he thought Miranda was terrible, but as Chief Justice, he upheld, actually, Miranda on a theory that, well, maybe it was wrong, but it's come to be part of our legal culture, our fabric, said William Rehnquist as Chief Justice in a case called Dickerson. So if we just always followed the precedents, even when they were wrong, we would soon drift away from the written Constitution. And I think that's a big mistake. But if we say generally we follow the written Constitution, but the written Constitution and itself allows us to treat precedent as a starting point because the judicial the courts are continuous, and as persuasive authority, because that's why judges give opinions, they give reasons, maybe those reasons might persuade, and the written Constitution allows judges to take into consideration reliance interest in deciding disputes between the parties. Things have already happened in the past. And the written Constitution also tells judges to pay attention to unwritten, unenumerated rights of the people, and those rights can exist by the people embracing an earlier constitutional decision that was maybe wrong when decided, but has now come to be embraced. That understanding of precedent, I think, makes sense of what the Constitution says about the judiciary. Happily, it also makes sense of what the judiciary has generally said about the Constitution. The precepts I've just offered, I think, actually make sense of the case law of the Supreme Court about case law. The Supreme Court has talked about the role of precedent, and in general, it's followed the precepts that I've laid down. In one case, a case called Casey, a lot of cases here, a case called Casey, involving the question whether Roe versus Wade should be repudiated or not, there was an extensive discussion of the role of precedent. It's a 1992 case called Casey. And there's a couple of sentences in Casey where the court seemed to say something very expansive about the role of precedent, but I, in this chapter on precedent, argue that Casey should be read a little bit more modestly. And when you read Casey with great care, and you read Casey alongside all sorts of other judicial opinions that the court has handed down, both before Casey and after Casey, the principles are actually the ones that I've articulated. We go with the written Constitution, and lower courts are bound, but lower courts are bound by the Supreme Court. And in the Supreme Court, precedent counts as a starting point, as persuasive authority, where there's been reliance interest, or where a new right has actually been embraced by the people subsequent to the judicial opinion. And thus understood, Casey fits with the Constitution, and the Constitution fits with Casey, and both of them fit with, in general, what precedent has said. What precedent says about the Constitution fits with what the Constitution says about precedent. What could be better than that? Let me finally tell you about these two people here. This is a fellow named Harry Blackmun. This is William Rehnquist. They were both justices in Roe versus Wade. Blackmun was for the right of abortion. Rehnquist was opposed to it. They then later joust, and so he dissented. Blackmun wrote the majority opinion in Roe. Rehnquist later becomes Chief Justice, and he's hoping to undo Roe. In a case called Casey, it doesn't happen. He ends up writing the dissent in Casey as Chief Justice. And again, an interesting discussion of the role of stare decisis in that case. Now, we haven't talked about Roe very much. It's one of the things that we're going to talk about in later lectures. We're going to have a whole series of conversations about women's rights in the Constitution. We're going to talk about other landmark statements that are important of constitutional principle, landmark statements that go beyond cases. We've been talking about cases a lot, and cases called Casey a lot. We're going to talk about important things that presidents have said over the years, and Congresses, and even private citizens about the Constitution. As I said, we're going to talk about women's rights. We're going to come back to Roe versus Wade. So there's still a lot of ground for us to cover. Stay tuned.